And finally, we have Mr. Paul Smith from the Campaign Legal Center. Mr. Smith, proceed.
Thank you, Mr. Chairman and members of the subcommittee. I appreciate the honor of appearing before you today to talk about a really important topic, how the Supreme Court comes up with the factual assumptions that underlie its constitutional decisions, especially in key election law cases like Citizens United and Shelby County. These kinds of factual assumptions, known as legislative facts, involve questions of how the world works or how a particular legal rule will operate in practice. In applying the Constitution, for example, in deciding whether a law passed by Congress is constitutional or not, the Supreme Court needs a factual basis. But in my experience as a student of the court, it generally functions better when it derives those facts from a trial court record or a legislative record. By contrast, some of the least defensible Supreme Court rulings have come about when the court disregards the evidence in the legislative record or the trial record and relies on factual assumptions that do not turn out to be remotely accurate. Take Citizens United, for example. As laid out in my written testimony, the court relied on the factual assertion that so-called independent expenditures in political campaigns, as distinguished from contributions to candidates, can never be corrupting. What was the basis of that assertion? That certainly wasn't a factual assumption accepted by Congress when it passed the provision of the Bipartisan Campaign Reform Act that was at issue. To the contrary, Congress relied on its intimate knowledge of how campaigns operate in deciding to extend the existing limits on corporate independent expenditures back in 2002. Nor was there any trial record supporting the court's assertion about the non-corrupting nature of independent expenditures. It could not be because Citizens United had decided not to make the argument that the law at issue was facially unconstitutional until the Supreme Court converted the case to a facial challenge after it was already up on appeal. Ironically, there was an extensive factual record on this very issue being developed by lawyers at the Federal Election Commission at precisely the same time. That was in a case called Speech Now. But that evidence became irrelevant once the court announced in Citizens United, essentially as a matter of law, that independent expenditures are per se non-corrupting. How did this all work out? Well, Citizens United led directly to the creation of super PACs, large PACs receiving unlimited contributions that make only independent expenditures. They evolved in many cases into single candidate super PACs working hand in glove with candidates and their campaigns. The notion that large unlimited contributions to that kind of entity can never buy undue influence or corrupt the candidate seems just silly. These institutions, these entities are indistinguishable for all practical purposes from the campaign contributions which Congress continues to limit. Shelby County presents a different but equally troubling scenario. In 2006, Congress had to decide whether to renew Section 5 of the Voting Rights Act, which required pre-clearance of voting changes in states mostly in the Deep South. Based on exhaustive evidence, it decided that this region continued to exhibit a desire to suppress voting by African Americans and Latinos, and therefore should remain subject to the pre-clearance regime. Congress then passed the extension of that law almost unanimously. How did the Supreme Court respond? Well, the majority in a 5-4 ruling simply rejected the factual conclusions of Congress and all of the evidence on which they were based. It issued a novel constitutional ruling invalidating this important act of Congress, premised on the notion that the states subject to pre-clearance had changed so much that this highly effective barrier to vote suppression was no longer necessary. The result was predictable and unfortunate. State after state passed laws that would have clearly failed pre-clearance because they were very, very likely to diminish access to the franchise for Black and Latino voters. The ability of advocates to push back on these laws was severely impaired. And often, even when the challenges that were brought were successful, the legislature simply turned around and passed more laws aimed at vote suppression. That's precisely what Section 5 was intended to prevent. That kind of whack-a-mole legislating, constant new innovation in means of vote suppression. To be sure, there are times when the justices need to make their own best judgments about the legislative facts in deciding cases. Not every case has a factual record, but the enforcement of constitutional rights has to continue. But it would be better if the court minimized those situations and relied on well-documented factual records wherever possible. Thanks for allowing me to testify today. I'd be happy to answer any questions you may have.